This is Natalie Rayner of Keller and Heckman. Can you explain more about what you do and your firm?
I am an attorney with Keller and Heckman in San Francisco, and we are a regulatory focused law firm with expertise in food and food packaging law in particular. We have an in-house scientific staff that includes chemists and toxicologists that help us do some of the more technical aspects of our work, including doing safety evaluations to evaluate whether new substances can be considered generally recognized as safe or GRAS for use in food. I've been doing this work for about 12 or 13 years at this point, and it's a lot of fun.
We're going to be talking about the regulatory status for CBD in food today. Could you give an outline of the 2018 Farm Bill and how that affects CBD in food?
In 2018, Congress passed the Farm Bill that changed the status of cannabis sativa from a Controlled Substances Act perspective. So that's more of what the Drug Enforcement Administration, or DEA's, status for cannabis is. It changed really what the DEA considered to be legal versus illegal hemp farming. But the 2018 Farm Bill changes really had no effect on the use of cannabis or cannabis derivatives like cannabidiol or CBD in food or dietary supplements. The status of CBD in food before the 2018 Farm Bill is the same as it is today, which is that there is no approved use of CBD in food or supplements at this point.
And that's on the federal level, correct?
That's right. At the federal level, the way to get to a good spot for CBD in food would be to either submit a food additive petition, or FAP, or to be able to support that CBD is generally recognized as safe, or GRAS, for use in food, or that it's a safe new dietary ingredient for use in dietary supplements. But at this point, there is no public GRAS notice. There's been no food additive petition submitted for CBD. So at the federal level, there is no clear status for CBD and other cannabis derivatives.
That's primarily because the FDA has it labeled as part of a drug for treatment in seizures.
FDA's position has been that there are provisions in the Federal Food, Drug, and Cosmetic Act, the FFDCA for short, that prevent it from considering CBD for use in food and supplements. There are two provisions in the act that say that drugs and substances that are the subject of publicly disclosed clinical studies cannot be considered for use as ingredients in food or supplements. There are counter arguments to that position. For example, possibly a reasonable interpretation to say that the types of CBD that are being used in food are not identical to the substance that was approved for use in treating a certain type of epilepsy. But FDA is just really taking a broad interpretation of this provision to say that these parts of the statute just prevent it from considering CBD's use in food, period. The name of that drug was Epidiolex, and it contains a purified form of CBD. So it's really perhaps not identical to the less purified forms of CBD, but FDA is taking the position that because Epidiolex was approved for use in drug, that it can't consider it for use in food and supplements.
And Congress has been fighting the FDA a little bit on trying to get that changed.
There's been some initiatives to sort of push FDA to reach a favorable position on CBD's use in food and supplements, but the majority of these proposals don't take into account that FDA is bound by a certain regulatory framework, and that framework doesn't provide FDA with resources to research a new food additive or new dietary ingredient on its own. FDA's position is really to review information that other parties gather and then submit to FDA for review. There's been one fix proposed in Congress, which would be to amend those sections of the act that FDA is pointing to as preventing it from considering CBD's use in drugs. So these legislative fixes would change the FFDCA to allow FDA to consider CBD for use in food and supplements, even though Epidiolex has been approved as a drug. But even that fix wouldn't permit FDA to then affirmatively conclude that CBD is acceptable for use in food and drugs. Someone would still need to gather the necessary data and submit it to FDA to make the case that these uses of CBD are safe.
How would you suggest producers and processors collect the appropriately robust data?
The amount of safety data that are going to be required by FDA will depend on the level of exposure to CBD. So the bigger the dose, the bigger the exposure, the more safety data would be required. I would imagine that the cost of developing the amount of data necessary to get to a favorable FDA position is going to be a very, very high cost. And so I can see various companies or trade association getting together all those resources, because it's hard for me to imagine that a small company would have the resources necessary to develop the necessary studies. This is not going to be like a $50,000 endeavor. This is going to be probably a multi-year, possibly $1 million or more investment. But it's really going to depend on what the exposure of interest is and then how much data you would need to support the safety of that exposure. If someone wanted to propose a very, very, very limited use of CBD, less safety data would be necessary than if you wanted to get it approved for use in, let's say, your bottled water product or as a supplement at a several milligram per day dose. The bigger the potential exposure, the more safety information you would need to develop.
Despite it being illegal on a federal level, many states have different regulations, and on the state law side, it was permitted within certain uses, correct?
This is where it gets really confusing and probably overwhelming. A bunch of different states have different legalized marijuana laws, either for medical use or recreational use. Even in states where you might have permitted uses at a state level, you might find localities that don't permit it to be used in a certain way. So different counties or different cities might take a different approach than even the states. The situation for CBD from city to city, county to county, state to state is going to vary a lot. And I think FDA has asserted its jurisdiction pretty broadly. So it's difficult to take the position that if it's okay at a state level or if it's okay in your city, that FDA would accept that you could continue to market that product. It's pretty easy to fall within FDA's jurisdiction because it does exert that jurisdiction pretty broadly over foods and supplements in general.
Is there anything else that you would like to add or explain to our listeners and readers?
I think it's good to note that we've done searches of the public literature to search for how much data is there about CBD at this point. And there really is limited published safety data on CBD. And it's also important, I think, to note that there's been some red flags raised in certain studies. So it's possible that even when someone does invest the resources to develop the kind of studies that you would need to support the FDA status of CBD, the safety data might not be entirely supportive. And that's going to just further complicate the ability to get FDA's favorable conclusion. I think that the road ahead for supporting CBD's use in food and supplements, it's not necessarily a straight path, and it might be a rocky road.
Thank you for taking time to talk with me today. How can our listeners and readers contact you if they have any questions?
You can email me at rainer@khlaw.com, or you can call at 415-948-2821, and we'll be happy to help with whatever questions you might have.